Good morning, everybody. I'm Asaf Ramarowski, the Executive Director of SPME, and it's my pleasure to once again welcome you to our BDS webinar series. This morning, we have the privilege and opportunity to talk to our friend and colleague, Professor Geoffrey Korn. Professor Korn is a professor of law. He's a prolific writer and researcher on the issues regarding military issues and law. He was served in the U.S. Army for 21 years as an officer and as civilian legal advisor, retiring as a lieutenant colonel. He's dealt a lot with military issues of conflict around the world. And this morning, obviously, he's going to talk about the latest, which is, of course, of interest to many of us regarding Israel's conduct and legal aspects regarding their war in Gaza. He's written a lot about these issues, so I urge everybody to look around for his articles on different aspects, which we're happy to share also after the program. The format, housekeeping wise, as always, those of you who have been with us in the past know, Professor Korn will talk for about 20 minutes or so. Then we'll go into Q&A. Q&A will be via the chat. All you got to do is type in your questions in the chat, and we'll do our best to get to all of them in a timely fashion. If we don't, as always, I apologize in advance. We'll do our best to respond after the program. But really, without further ado, Geoffrey, thank you for joining us, and the virtual floor is now yours.
Well, thank you for having me and giving me the opportunity to share some of my thoughts about what we see happening over in Israel and especially in Gaza. Let me begin by a quick summary of my involvement in some of the review of these operations. As Asaf said, I'm a retired Army officer. I was a military intelligence officer to begin with, and then I became a legal officer, a judge advocate after the Army sent me to law school. And I focused my career principally on criminal law and international, what we call operational law, the military operational implementation of international law. I finished my career in uniform and spent 1 year as the Army's senior advisor on issues related to the law of war. And then I went into academia about 20 years ago. Specifically with Israel, I have been involved on a number of review missions with a group of senior U.S. military officers, not lawyers, former combat commanders at the 3- and 4-star rank level, through the Jewish Institute of National Security Affairs and through what's called the high-level military group that's run by Richard Kemp over in the United Kingdom. I've done 2 visits to Israel, one in March of 2022, the other in July of 23, and met with leaders from the very top of the Israeli military, the J3, the chief of operations, down to company command level. We spent a day in Gaza last year at the Rafah crossing with the infantry brigade that was responsible for operations in that area. And I contributed to a number of reports related to the conduct of hostilities in the campaign. So that's a good place for me to start emphasizing what I'm going to be discussing and really what I'm not going to be discussing. My focus today is to help people understand how to assess the legality of military operations during the conduct of hostilities. Now, there are lots of aspects of military operations, or what we might say broadly, military or national security policy, that raise very emotional reactions vis-a-vis Israel. I don't consider myself an expert on Israeli national security policy. I do consider myself an expert on how the law regulates and influences the way militaries fight, whether they're fighting against a conventional enemy or whether they're fighting against an unconventional enemy like the Israelis are fighting in Gaza. So what I'm going to try and do is to outline first for you the way a military commander assesses the legality of using force in battle. And it really wouldn't matter whether you're talking about a platoon leader commanding 40 soldiers or a corps commander or division commander commanding 20 or 30,000 soldiers. The methodology is the same. The sophistication of the analysis would obviously be different, but the methodology is the same. And then what I want to do is identify what I think are some sources of misunderstanding and confusion. Because if you're like me, you recognized almost immediately after October 7th that there are really two wars that are going on related to Gaza. The one is the kinetic war, the war that's being fought by Israeli citizens in the IDF on a daily basis in the dirt and the rubble, and unfortunately the blood of Gaza. The other is the war that's being fought in the international information domain. And in fact, I think that war has become far more challenging for Israel than the challenges confronted in battle. Now, that's easy to say for someone who's not in that battle, and I don't want to minimize at all the human tragedy of being sent into war on behalf of your nation and the challenges that that presents. But for Israel's security situation and its status as a member of the community of nations, it's that broader strategic information campaign that has become almost overwhelming. If you're like me, then you probably have experienced battle fatigue at that level, the way a soldier experiences battle fatigue on the battlefield or in the battle space. It almost feels like a relentless um, pounding of misinformation and disinformation that I'm constantly trying to respond to rationally, oftentimes with a sense of futility because it starts out with an irrational premise or presumption. But on the other hand, I also recognize, and I think we all recognize, that we can't abandon the battlefield. There have to be voices that try and explain why the overall perception that the IDF is illegitimate, indiscriminate, has no consideration for human suffering, and is an agent in the practice of genocide is completely false. And that if we look at the way law regulates war and we assess the conduct of the Israeli Defense Forces, it paints a completely different picture. So making that point has to be a constant response to the strategy of the enemy, which is to create a false narrative of illegality. And through that false narrative of illegality, create a delegitimization at the strategic level of the enemy to gain advantage. And we've seen this. We've seen it recently. I mean, the decisions by the French, the UK, the Canadian, the Australian political leadership to extend recognition to the Palestinians is being cheered by Hamas as a manifestation of victory. And I think it's deeply unfortunate that these nations don't recognize the consequence of those decisions. That's a political diplomatic issue, but the conditions for that political and diplomatic issue were set by the misinformation and disinformation related to the war itself. When I went in 2014 after the flare-up of hostilities between Israel and Hamas that lasted about 60 days, the first time the Israelis realized that Hamas had built a tunnel network under their border. I was with a retired major general, two-star general from the U.S. Army, a guy named Mike Jones. We wrote a report. We were doing presentations. I think we were in the United Kingdom doing a presentation to staffers who worked in Parliament. And he said something that I'll never forget because he really hit the nail on the head the way commanders tend to do. They cut through a lot of the hyperbole and get right to the point. He said, when I was a young tank officer, I was taught that information is a supporting effort to combat operations. What I learned studying the conflict between Israel and Hamas is that for Hamas, it's the exact opposite. Combat is a supporting effort to their information campaign. They don't expect to win on the battlefield. They know they can't win on the battlefield. What their goal is to create information ammunition that they can use to delegitimize Israel and the Israeli effort, and ultimately force Israeli political leaders to put the brakes on operations before they achieve decisive effect. Now, one other caveat I'd like to make. I am not talking about the wisdom of military strategy. That is a separate debate. There are people that I visited Israel with, retired generals, retired military officers, who have been critical about the idea of initiating a major offensive in Gaza City. That's a strategic policy decision. My job as a military lawyer or a national security lawyer would be to advise the policymakers, the commanders, the political decision makers on what their legal maneuver box looks like. And I don't think there's anything illegal or prohibited about conducting such a campaign. Whether it's a wise use of resources and the best strategy to move forward with is a separate issue. So it is a simple principle of military legal advisors that your job is not to decide whether a decision is a smart decision or the best decision. Your job is to advise your commander on whether the commander has legal authority to make that decision. Now, if the commander seeks your thoughts on the overall wisdom of a decision, that's fine. That's the role of being a counselor. But I'm not conflating those two. So the biggest, what I call corrupting or distorting effect on assessing the legality of Israeli military operations in Gaza is the tendency, the almost pervasive tendency or instinct to engage in what I've called effects-based condemnation. What I mean by that is observers will look at the consequences of battle, and the consequences of battle in Gaza are profoundly destructive. I mean, we can debate the numbers of civilian casualties, but there's no question that there's been a large number of civilian casualties in Gaza, and most of those civilian casualties are civilians who are uninvolved in hostilities. And I'll come back to that word in a moment. Or the physical destruction of Gaza. If you're there, if you've been there, if you've flown over it, you see that it really does look like a German city at the end of World War II. There's massive physical destruction in Gaza. And so you extrapolate from that the undeniable conclusion that the party that is inflicting that harm must be acting illegally. The problem with that is that the law that regulates the use of force in battle, number one, doesn't regulate it based on an aggregate effect. So when people say, and I hear this all the time, the Israelis have killed 30,000 civilians, that's too many. I respond by asking a simple question. If that's too many, how many is okay? And no one can answer that question because it's an inherently arbitrary accusation. But more fundamentally, if you're arguing that that shows that the military attack decisions are disproportionate, you are using an aggregate consequence of an overall campaign to condemn individual attack decisions. So the reason that this is so distorting is because the law doesn't dictate the legality of an attack by outcome. The law dictates the legality of attack by the attack decision. It's what we call the reasonable commander standard. The commander has to make a reasonable judgment, reasonable under the circumstances prevailing at the time, that number one, he's attacking a legitimate military target, that number two, if civilians are at risk, he or she has done everything feasible to mitigate that risk and drive it down as much as possible. And number three, if that mitigation has not eliminated the risk, that the attack will not have a disproportionate adverse consequence on civilians or civilian property. The irony here is reflected when we think about the constant condemnation of Israeli military operational decisions as illegal and the almost incomprehensible disregard for all of the efforts Hamas made early in the war to kill Israeli civilians. So let's take two commanders. You have an Israeli commander who's deciding to attack an enemy strong point in a building. The commander knows that there are civilians in the building. The commander has done everything feasible to get those civilians to leave, issued warnings, provided an operational pause, but for whatever reason, the civilians haven't left. Maybe Hamas won't let them leave. Maybe they just think they're safer where they are. So the commander conducts the attack, and unfortunately, while attacking the legitimate target, the commander ends up killing several civilians. So what we see in the news is Israeli attack kills civilians. At the same time, Hamas commanders are ordering rocket attacks against Israel without even trying to hit a military target. Their goal is to terrorize the civilian population by inflicting casualties on civilians. Fortunately, Israeli missile defense capability intercepts those missiles, or maybe they just malfunction, and the Hamas commander fails to produce the intended effect of killing civilians. Who is going to be condemned in the international space? The Israeli commander, because he killed civilians. And who is going to be ignored? The Hamas commander, because he didn't achieve his effect. And ironically, the law says it's the exact opposite. It's the Hamas commander who is clearly acting unlawfully because he's trying to kill civilians, and it's the Israeli commander who acted lawfully because he did his best to avoid killing the civilians, but couldn't avoid it in order to achieve the military objective. So this is what I mean about the corrosive or distorting effect of or consequence of effects-based condemnation. The law doesn't work that way. Now, that doesn't mean attack effects are irrelevant. They are relevant in assessing whether the judgment was reasonable at the time. So if we look at Ukraine and we see Russian commanders launching attacks against buildings that under any circumstances have no military value, then we can infer from those effects, the destruction of the building, the killing of civilians, that the commander was in fact intending to kill civilians. But as soon as you put military value into that building, or as soon as you demonstrate that the commander made an effort to get civilians out of that area, it makes it much more complicated to rely exclusively on attack effects in order to infer an illicit state of mind. So I think the best way to explain this methodology is through a chart that I created a couple of years ago, which I am now going to try and share with all of you. And then I'm going to walk through it, and this will show you the way the rules of war actually work for any attack. Again, this wouldn't matter whether I was a soldier with a rifle trying to deciding whether to shoot back at an enemy soldier who's using a child as a human shield, or whether I'm a regional or corps commander deciding whether to conduct an air attack or a missile attack against an enemy target. Everything begins with a proposed target. Now, targets can be pre-planned, where I have a lot of time to plot out what the target is, what the risk to civilians would be, what type of measures I could take to mitigate the risk, and to do a proportionality assessment. When you're doing deliberate targeting, for example, I'm sure that all of the targets that Israel attacked in Iran had been carefully assessed, pre-planned. This is what we call deliberate targeting. You will develop what's called a collateral damage estimation packet. The commander will be informed with as much information as possible about the nature of the target, the value of the attack methodology, the risk to civilians, the risk to civilian property, in order to inform the decision. But targets, particularly in a fast-moving maneuver campaign like Gaza, are often what we call time sensitive. In other words, we don't have the opportunity to do that deliberative process as carefully. And where a target falls on that spectrum of timeliness is going to influence the reasonableness of the attack decision. So we start with the proposed target, and we have to ask two questions. Is it a legitimate military objective? To be a legitimate military objective, if it's a human target, there has to be a reasonable determination that the individual is either a member of the enemy armed group, what I will call a belligerent, what most people call combatant, which is actually legally overbroad, because a combatant is under the law a privileged belligerent, meaning fighting for a state, following the rules of war, entitled to be a prisoner of war upon capture. I don't think anybody fighting for Hamas is a combatant. They are belligerents. So one way to think about this is all combatants are belligerents, but not all belligerents are combatants. But if you are a belligerent, you are a lawful target or a lawful military objective. The other people you can deliberately attack are civilians who take a direct part in hostilities. Now, we could spend an hour talking about what that is, but in essence, it means they are relatively proximate to the kill chain. So if a civilian picks up a rifle and shoots at me, he's taking a direct part in hostilities. If he's directing enemy artillery by giving him information about where my location is, he's taking a direct part in hostilities. By the way, this is why I referred earlier to uninvolved civilians. Forever, we had a tendency to refer to innocent civilians. We say, well, you can't kill innocent civilians. I think that's dangerous because when we say innocent, we're suggesting maybe that they don't support the enemy. You can support the enemy. You can cheer for the enemy. As a matter of fact, most people who are fighting in a war are cheering for their side. You can hope the enemy prevails. That doesn't make you a target because you're not involved in the hostilities. When you take a direct part in hostilities, you forfeit your protection from attack. So if it's a person, it's either a belligerent, an enemy member of an organized armed group, or a civilian taking a direct part in hostilities. If it's a place or a thing, then it has to qualify as a military objective within the meaning of the law. And you have the definition of military objective. Let me make this a little bigger if I can. There. Does destruction, capture, or neutralization offer a definite military advantage under the circumstances ruling at the time of the attack? Notice you can make a mistake. You can attack something that turns out not to have been a military objective. But so long as your judgment was reasonable at the time, you have complied with the law, which is another important axiom when we push back against these false narratives. Not all mistakes in war are unlawful. Mistakes can be reasonable or unreasonable. What the law prohibits are unreasonable attack decisions, not reasonable attack decisions that turn out to be erroneous. So if we start here and we ask this question, is it a military objective? In other words, is the person an enemy operative, or does the place or thing meet the test for military objective? If the answer is no, you may not attack. So when Hamas was shooting rockets at Israeli civilians, they were violating the first principle of legality of attack. They were violating the principle of distinction because they were intentionally launching attacks against places and things that were not military objectives. In contrast, when the Iranians were firing rockets at Israel, some of those rockets were directed at military targets. So that was legitimate in terms of the first step of legality analysis. If the person, place, or thing qualifies as a military objective, the next question we ask is, will attacking it create risk to civilians or civilian property? If the answer is no, you're done with your legal analysis, essentially. In other words, the rule of precautions and the rule of proportionality only comes into play when you assess risk to civilians or civilian property. Now, candidly, in Gaza, you're never going to have that situation, or almost never. I think maybe if you were launching an attack on enemy operatives in a tunnel and the attack would not endanger civilians, then you might be there. But, if you're fighting ISIS in the Syrian desert and you find a column of ISIS fighters out in the middle of nowhere, they are a military objective. There's no risk to civilians or civilian property. Your legal analysis is essentially done. And that's an important point I want everybody to remember. There is no proportionality rule under the law of armed conflict that protects the enemy. Proportionality protects the collateral effects of attacking an enemy. So if there are no collateral effects on civilian or civilian property, you can use overwhelming force to kill or destroy that enemy. Now, that's not very common. So most of the time, you're going to answer yes, there is civilian risk. The next step is to implement what we call feasible precautions. Have all feasible precautions been taken to mitigate civilian risk? Now, interestingly, when I learned the law at the Army JAG School, when I used to teach it back in the early 90s or the mid 90s, we didn't really talk too much about precautions. We said distinction and proportionality. So is it a military target, and will the attack be disproportionate? And about 15 years ago, I started writing about this, and I basically was writing articles trying to make the point that this precautionary rule is not only the neglected stepchild of legality analysis, but it is actually probably in practice much more important than the proportionality rule. And that's because it's more objective in nature. Put yourself in the position of a commander. We're going to see that if the commander is having to apply the proportionality rule, he has to decide whether the consequence to civilians of attacking that building that had that Hamas headquarters in it would be excessive in relation to his anticipated military advantage. But the law does not define the word excessive. Excessive ends up meaning whatever anybody wants it to mean. So as a military lawyer, I would tell the commander what the rule is. You are not allowed to attack that target if you think the collateral damage will be excessive related to the military advantage. Every commander is going to look back at the lawyer and ask a simple question. What does excessive mean? And the lawyer is going to say, I can't answer that for you. That's your judgment call. I just finished an article for the International Law series published by the Naval War College titled Proportionality, Can't Live With It, Can't Live Without It. And part of the article was making the point that proportionality is really valuable if you want to condemn a military operation, because you can make it mean pretty much anything you want it to mean. Precautions are more aligned with a commander's instinct. What do I mean by precautions? Things like altering the timing of your attack, altering the weapon system, using a different tactic, maybe attacking a different target that will give you the same military advantage, issuing warnings, doing operational pauses that enable the civilians to evacuate, providing for evacuation corridors, gathering more intelligence to make sure that you've got the best information possible. When commanders make attack decisions, these are instinctive. So if I'm in the meeting and we know we're going to attack this building and we know civilians are at risk, I can look at the planners and say, have you considered using a different weapon system? Or have you considered timing the attack at a different time where there will be less risk to civilians? If there's civilians, if there are children in the house that are going to go to school in the morning, why not wait until the afternoon so they're not in the home when you launch the attack? This is instinctive for commanders, and I think, number one, it has a more significant civilian protective effect because the range of options is broader. But number two, and I'll get to this again at the end, is if we really want to assess good faith efforts by military commanders to advance the humanitarian goals of the law of war, which in part are to mitigate risk to civilians, this is an ideal touchstone. Because if you're not implementing precautions that appear to be feasible, that suggests that you don't care about protecting civilians. On the other hand, if you're making significant efforts to do so, that suggests that you are. Let me give you one specific example. In 2003, in July of 2003, when we visited Gaza, we met with the Air Operations Center for Southern Command. And we were talking with a colonel who was in charge of approving requests for close air support attacks, fixed wing weapon systems, helicopters, and drones. And I asked him, I said, what percentage of requested attacks do you think have been canceled or delayed because of the risk to civilians? I thought he would say maybe 10%. He looked up, he said probably 50%. Half of all requested attacks were denied or delayed because of a decision to do so to mitigate civilian risk. That's a story we don't hear. And why don't we hear it? Because it doesn't make news when you have a headline that says Israeli commander chooses not to kill civilians. as a precautionary measure. But if we're being candid, it's those type of statistics and those type of decisions that demonstrate the genuine good faith of military commanders. Now, the precautions obligation is not absolute. It's qualified by feasibility. What makes a precaution feasible? Two things. First, you've got the capability to do it. If I don't have a precision guided munition, I can't use a precision guided munition. If I don't have the phone numbers of all of the residents of a certain area, I can't send text messages to all of those residents. So I've got to have the capability to do it. But number two, doing it will not compromise my military advantage. So the law says you're not required to implement the precaution if doing so will have a detrimental consequence on your military advantage. Obviously, the Israelis didn't issue warnings to Iranian civilians before they launched their attack on Iran because it would have put Israeli aircraft in greater danger by alerting the enemy. Although, ironically, I think if we look at the record in Gaza, you will see many situations where commanders say, I know I'm not legally obligated to implement this precaution, but I'm going to do it anyway, because I think that there are important moral, political, informational reasons to do so, which again is a manifestation of good faith. Once you've implemented all feasible precautions, you get down to the last step, which is the proportionality analysis. Probably the most widely misunderstood rule in the law in public discourse. And why do I say that? Because, number one, proportionality in war, unlike the proportionality rule that police operate under in peacetime, does not protect the deliberate object of attack. Remember, the enemy is not protected by proportionality. It protects the civilians and civilian property that are proximate to that target. And number two, what people don't understand is that the rule in the law never uses the word proportional. It uses the word excessive. So if the commander has pushed down civilian risk as much as feasible using precautions, the last step is to ask, is the expected incidental harm, incidental killing or injury to civilians or destruction of civilian property, considered excessive in relation to the concrete and direct military advantage the commander expects will result from the attack? If the answer is yes, the attack is prohibited as indiscriminate. If the answer is no, then it is permissible to launch an attack knowing it will result in civilian casualties. And again, the problem with this rule from a practical standpoint is there is no consensus on the meaning of the word excessive. And the other problem is it tends to be critiqued on an aggregate basis. 30,000 civilians is excessive. The problem is the rule applies on an attack by attack basis. So we go back. Well, let me step back a minute. Again, I don't think this is an irrelevant rule. I actually think it's a very important rule because I think it's the ultimate manifestation that even in war, the ends cannot always justify the means. There are some times where a legitimate end is not sufficient to justify the consequence to the civilian population. The problem is where we draw that line. And so this goes back to where I started with the distorting effect, the distorting consequence of effects-based condemnation. If you look at the effects of an attack in a place like Gaza and say that attack must have been illegal, you're missing two critical points. First off, that's like me telling you 1 plus I don't know equals 10. The 1 is the destruction. The I don't know is all of the information about the target, all of the assessment about civilian risk, all of the effort to mitigate civilian risk. If you don't know that, then you cannot critique application of this flowchart. The other problem is it conflates direct cause with legal responsibility. And by doing so, it omits consideration of the measures the enemy took to create risk to the civilian population. Now, that doesn't release me from these obligations. If I know Hamas is using human shields, or even worse, wants to get its own civilians killed, I'm still required to follow these rules. But it certainly makes mitigating or preventing that civilian risk much more difficult under the circumstances. I'm going to close the share now. So when you discuss the war and you respond to people like I do frequently saying, this can't be right, just walk through this process. Say, do you know why the target was attacked? Do you know what the commander knew about the target? Do you know what the commander did to mitigate civilian risk? And at what point would you say it's not permissible to attack a legitimate target when the commander has done everything to get civilians out of the area, but the enemy hasn't? Now, one more final comment, then I'll take some questions because I saw one hand was raised. I was a military prosecutor. I am not naive. No military is perfect. I don't think that the Israeli military leadership does itself any favors when it uses kind of hyperbole like the IDF is the most moral military in the world, or the IDF is the best military in the world for complying with the law. I mean, I would take issue with that. I think our military is pretty good, but it's not perfect. And theirs is not perfect either. You cannot conduct a campaign of this density, intensity, duration against an enemy like Hamas without expecting there will be some violations. It's inevitable. But what we should judge the organization on is not the isolated incidents of violation. It's on the overall record. And I think that overall record is very, very positive. I also think that the Israeli military, and particularly the Military Advocate General's Corps, the military lawyers, there has to be more transparency and dispatch in investigations and disciplinary actions when there are violations. Because even I look at some incidents that I see in the news and I am deeply troubled by what I see, and I want to know what's happening, who's investigating it, what is the status of the investigation. That is a very difficult tightrope to walk because you also have to consider the integrity of the investigation, the protection of the rights of the service member that's under investigation. But I think if I had one strong recommendation for IDF leadership, it would be you have to start erring more on the side of transparency and openness on how you're dealing with the isolated acts of misconduct by your own forces, because that is part of your obligation to take precautionary measures, to demonstrate to the force that there will be consequences for violating the rules, even when you're fighting an enemy that doesn't care about them. And that's my presentation, Asaf, if we want to open it up to questions.
Yes, indeed. First of all, thank you for that. That was beyond impressive and very thorough for and walking us through all of these critical issues that we're all dealing with. I have a lot of questions, and I'm sure Alex does as well, and I'm sure the audience. Let me take the prerogative of asking the first question, then I'll have Alex, then we'll go to the audience, and then we can take it from there, sticking to our time. I do like and appreciate a lot your distinction between belligerent and non-combatant, which I think is something that is missing from the conversation. When you're looking at the Israeli narrative and looking at how the Israelis conduct themselves, part of the lost in translation that we're observing is that they don't make that distinction. And I think that part of the issue that we're seeing that's coming out, and obviously through all the arteries of social media and everything else, is how they're able to explain the belligerency that you're talking about when it comes to urban warfare, and that dynamic, and how they obviously define what are legitimate targets within that larger architecture. We have a very different way of doing business, and obviously, as you explained correctly, between how the U.S. conducts itself. Can you, what is your recommendation for the Israelis to deal with that, especially when it comes to urban warfare, as far as explaining legitimately the belligerency of these targets, specifically when it comes to the civilian neighborhood, like we saw with the hospitals and things like that, that I think that come up a lot, and of course are harder for laymen and to understand, in that conversation.
It's such a great question. So let's start with a basic principle. If I am a commander and I have to decide who to attack, I need threat identification indications. I need to know what the threat looks like. When I was an intelligence officer in the Army in 1984, that wasn't hard. We knew what the Soviet Army looked like. They wore uniforms. Their equipment had flags on them. If you're in Ukraine, it's a little bit more complicated because your uniforms often look like the enemy, and you see Ukrainians wearing yellow armbands to identify themselves. When you're fighting a illicit enemy like Hamas or Hezbollah, well, less Hezbollah, they actually often would wear a uniform, but Hamas, Palestinian Islamic Jihad, Al Qaeda, ISIS, the Taliban, they're deliberately trying to make your identification process more difficult, not by camouflaging themselves in the desert, but by camouflaging themselves by making themselves look like civilians. So the threat identification criteria have to become different. They're not the normal, just look for a uniform. The problem is if you're transparent about that, you're telling them what it is, which means they can then alter their pattern of behavior. I don't know. Honestly, I don't know what they are. And I remember I did a hearing in front of the Senate Armed Services Committee on Al Qaeda, and one of the senators asked a law professor, how do we know who a target is when we're doing drone attacks? And the professor said, I don't know, and I would really love to know that. And then they asked me, and I said, I would love to know it as well. I shouldn't know it because it should be classified, because if I know it, it means they know it, which means it's going to enable them to avoid our ability to attack them. The other piece of this is it makes the reasonable mistake much more likely. When your enemy is using every civilian home as a battle position, and you're a commander and you're having to clear a road, you are going to err on the side of attacking each house as if it's a battle position. Now, inevitably, you'll probably attack one that wasn't a battle position. But that's because of the enemy's conduct that has created that expectation. So when you're fighting an illicit enemy that doesn't follow the rules of war, that tries to cloak itself in civilian status, what we saw in Gaza when I was there was Hamas had pre-positioned weapons in every building. So what their fighters would do is they would walk around as if they were civilians, pop into a building, pick up a weapon, engage in hostilities, drop it, move on to the next battle position. That is going to create a higher probability that when you make your attack decision, it may turn out to be erroneous. And this is the problem with these numbers we hear thrown out. 30,000 civilians, 40,000 civilians. Of course, Hamas doesn't distinguish between enemy belligerents and civilians. You haven't seen the Israelis come back aggressively and say, here are our numbers. And I think for good reason, because they're probably not positive. They can't be positive. And unlike the health ministry of Gaza, who has no constraint on giving out false or erroneous information, if you're the Israeli government and you give information that's suddenly rebutted objectively, it looks like you're going to be attacked for giving false information. I think for me, the point I try and make all the time is I don't know how many civilians have died in Gaza. Nobody knows. There are many of them probably under rubble. We know civilians have died. We also know that the Israeli military would have to be the worst military in the world if 90% of the casualties were civilians. That can't be true. So we have to wait until the literal and proverbial dust settles to try and figure out in more detail what this ratio of civilian to enemy fighter is. And one more point. Even if we take a ratio of 2 civilians to every fighter or 3 civilians to every fighter, ironically, for urban warfare, that is historically low. The historic norm is about 10 to 1, 10 civilians for every one enemy. So even in the worst case scenario, you have a statistic that actually suggests the Israeli military is doing better than most militaries fighting in that type of environment.
Great. Thank you for that. Appreciate that. Alex, to you.
Sure. You anticipated one of my questions, and that's the legal ramifications of fighting in a militarized environment, a three-dimensional battle space that's above ground, that's below ground, that where every compartment is militarized in some sense. and which changes the equation regarding threat perception as well as force protection for from the Israeli side. So I want to switch gears a little bit and talk about ask you about really a cultural question. The critique of Israeli actions generally conflates all aspects of something called international law. It's all dumped into this hopper. Law of armed conflict, international humanitarian law, international human rights law, all sorts of other things which get blended together and thrown like a frappe as a series of accusations. And my question is, why are not simply the public, but why are political leaders who should know better so ignorant of these critical distinctions? Are they not advised? Do they decide to conflate these things for political gain? What is your perception having dealt with these such people?
Well, first off, you say should know better. I think a lot of political leaders don't understand the law. They
Right.
don't understand the methodology I just went through. I've done presentations, for example, on Capitol Hill to staffers who are trying to inform their political decision makers. I think that's part of it. I mean, this is not intuitive. I mean, let's be honest. The idea that you can see with your own eyes this level of destruction and say that's not how we judge whether the law is working is somewhat counter instinctive. I have a colleague at the law school who teaches public international law. He's never been in the military. And we were having this discussion. He says, yeah, but I see with my own eyes. You can't tell me what I'm seeing is okay. So part of it is the challenge of projecting yourself into the position of being a military commander in battle, trying to make decisions. Now, you talk about force protection. The law doesn't give me a right to prioritize the life of my soldier over the life of a civilian. But military doctrine teaches me I've got to preserve my combat capability in order to achieve follow-on missions. I can't waste everything in the first battle. So commanders instinctively are taught you have a three-tier prioritization of effort: mission, men, equipment. First, achieve your mission, do it in a way that preserves your personnel, and then preserves your equipment. Why men and equipment? Because if all of that is gone after the first operation, I lose the war. So yes, the instinct to look at results and say this can't be right is problematic because it devalues the challenge of combat for the decision maker. And by the way, when we were in Israel with the first time with our generals, we were meeting with Ron Dermer, and he went around the room and he said, after your week, what's one recommendation you have? Mine was stop talking about fighting terrorists. When you talk about a fight against terrorists, the perception outside of Israel is it's a bunch of guys with slingshots and bows and arrows fighting a juggernaut military. You're not fighting terrorists. You're fighting an enemy army. Now, it may be an enemy army that engages in terrorism. There's no question. But even your own narrative is contributing to this perception of overmatch and overzealousness. So part of my soapbox has been make people understand the true gravity of the threat that Israel faced after October 7th and the military challenge of doing what military maneuver forces are trained to do: close with and destroy your enemy. I don't know if that answers it at all.
That's good. Alex, I'm going to go on to the audience about
Please.
Just
Please.
keeping an eye on the clock here, so I know that I know Geoffrey's time is short as well. So we got a bunch of questions, Geoffrey. Let me try to combine them for you and try to so you can tackle them. I know there are no short answers. One of our members, Alan, is asking about the this is again goes to the configuration of the Israeli army to begin with, but going into the legality of Israelis who serve in the IDF, because if they're not, when there are reservists and when they're in active military duty, and when you're dealing obviously with a people's army that Israel has, obviously Hamas regards all of them as legitimate targets. Is that an element that also plays into all of this? And how do you know, is there a way to legally
Yeah.
kind of
It's a great question. So the question basically is if you know that all Israeli men and women of a certain age are subject to conscription or maybe being called up to service as reservists, aren't they all military targets? And the answer is no, because you have to wait until the objective indicator is that they are what? That attacking them is going to give you a definite military advantage in the circumstances ruling at the time. So once they're called up, once they're mustered, of course, they're military targets. But if we allowed an enemy to say, I'm allowed to attack the civilian population because they may get called up into military service, that means every civilian is a potential target. If we went to war with Russia or China, the Chinese could say, well, the Congress could resurrect conscription and all these people would be in the military, so we're allowed to kill them. That's a slippery slope. And that's why the language of the law refers to that definite military advantage in the circumstances ruling at the time. The entire point of that language was to put a barrier to speculative attack decisions. Remember Churchill, if I can kill the worker in the factory during the day, or I can kill him in his bed at night. Either way, he's not making ball bearings the next day. Everything becomes a military objective if we don't have that circumstances ruling at the time qualifier.
Great, thank you. So Olga is asking about the legislative acts that provide the principles for whether the attack is within the law of war. Can you go into that a little bit more?
I'm not exactly following the legislative acts. I mean, there are most countries have incorporated into their criminal statutes crimes in violation of the law of war. For example, the United States has the War Crimes Act of 1998, which makes it a federal criminal offense to commit certain war crimes. But most countries don't um, provide a statutory or legislative incorporation of the rules of war for the conduct of military operations. That is normally integrated into military doctrine, policies, or manuals. So the IDF, the United States, the British, the Canadians, the Australians, the French, the Germans, the Danes, they all have law of armed conflict manuals. By the way, I should have said, Alex, to your question, when we talk about the law of armed conflict and international humanitarian law, they're the same thing. That's the law that regulates war and protects victims of war. The term IHL, or international humanitarian law, has gained a lot of momentum over the past couple of decades. But the United States has always pushed back against that a little bit because our military leadership has always been concerned. It suggests that the principal focus of the law is humanitarian protection. That's an important focus of the law. But an equally important focus of the law is facilitating the ability to close with and defeat your enemy. Human rights law is something different. It doesn't completely stop functioning during time of war or armed conflict, but most of the compliance with human rights is dictated by the law of armed conflict. So we could say that the protection against the arbitrary deprivation of life never terminates, but whether a deprivation of life is arbitrary in a time of war depends on whether you're a legitimate military target, et cetera, et cetera.
Going back to your point about, about the act of war, is the act of war in Israel, that legislating that in its construct, is that the same as it is here in the States as far as the way that they interpret that and the way that they've been, because it's also been used obviously as a protection for the prime minister and whatnot, as a way, and the politics that are involved in the way the entire government has been conducting itself. Is that synonymous to how it's done elsewhere?
Oh, so maybe the question had to do with whether or not the state is going to legally authorize the war
Right.
through some type of act. No, I think it's very different in Israel. And one of the main differences is because the Israeli judiciary doesn't in any way follow the same doctrine of political question and judicial deference to wartime decision making as we do in the United States. So, for example, the Israeli High Court of Justice would not hesitate to assess a complaint that the Israeli military was not following certain rules of war. We've seen this. I mean, just recently, what the issue is Gaza occupied? What are the humanitarian obligations? I don't think U.S. courts would entertain those decisions, whether or not Congress had authorized the war, because in our system, we can be in an armed conflict without legislative authorization. Now, we can debate that all day long constitutionally, but we know it happens. When President Trump ordered Operation Midnight Hammer against Iran, he didn't go to Congress and get authorization. And every administration before him for the last probably 100 years every legal advisor would have said you don't have to get permission from Congress to do something like that. I don't know the parameters in Israel, but I think that the Israeli judicial mechanisms are much more engaged in critiquing compliance with not just their domestic law, but also international law. They have much more of um, a unitary system of the application of international law than we do. I mean, we have this dualism system where the law will become judicially enforceable when it's been integrated into statute. I think the Israeli courts are much more likely to look at treaty and customary international law and say, we have the ability to hold the Israeli military accountable for complying or non-complying with that law.
Great. Alex, I'm going to let you have the last question, keeping an eye on the clock, for Geoffrey's time. So go for it.
What what should be done to educate the public more about these critical distinctions? You're a professor, you teach law students.
I told you at the beginning that I mean, I think people like me, or maybe like people in the audience, we are ourselves experience a sense of combat fatigue. Like you just feel worn down making the same arguments, the same discussions, the same debates. I mean, I'm on Facebook, I see all the time, how can we allow this genocide to happen? And a year ago, I'd be responding, do you understand what the definition of genocide is? What's your proof of genocide? And more, I find myself just kind of, whatever, ignore it. You're not going to influence. Here's what I think. I think what we have to do as scholars, especially, is scholarship. We have to be candid. This is my point about I'm not naive. I know there have been violations, and I've been critical of some of the decisions that have been made. I think some of the decisions related to access to humanitarian aid have been foolish. They may have been legal, right? But we all know as lawyers that just because something's legal doesn't mean it's always the right thing to do. You're creating a strategic Achilles heel for yourself. So I think we have to be candid when we see things that we think are dubious or questionable. We have to be willing to say that. Because one thing I will say for most critics of Israel that I encounter, and especially of the IDF, they never say anything positive. Like, is the IDF really that bad that they don't do anything right? I mean, what do you say to that air commander who cancels 50% of requested attacks? That you're immoral? You're illegal. So that to me shows the lack of credibility. The other thing I think we do is do what a good lawyer does, cross-examining an expert who gives an opinion. You don't attack the opinion. I mean, if you're giving me an opinion on the witness stand, I'm not going to say, you don't really believe that opinion, do you? You attack the foundation. So when we hear these opinions that are so critical or so inclined to condemn, what we should be doing instinctively is looking at the foundation that the opinion rests on, because this is what we know. Opinions are only as credible as the quality of their foundation. So that's why I say, people will say to me, the Israelis have killed too many people in Gaza. And without being dismissive of the human cost of the war, I'll always ask the question back, okay, how many was it okay to kill? Because if you can't answer that question, you're just making something up. And you can't answer that question because the law doesn't give you that answer. And even if it did, you don't know the foundation for its application. So I think you just have to continue to do what the Israeli soldier is doing in the dirt of Gaza, grind it out. Fight this kind of enemy that is very difficult to encounter and very difficult to defeat because it's slippery. But you can't stop fighting because then you cede the field and you're giving up. That's the best I could offer, I think.
Great. It's a good place to, it's a good place to end, but we appreciate that, Geoffrey. So really, I want to thank you for your time. I mean, really, you did, it's great to hear your take on all of this, and thank you for sharing all your insights. I know everybody appreciates there's a lot to discuss, and of course we are all the barrage of these kind of accusations are something that we deal with all the time, and so it's critical to understand, especially from the legal standpoint. So really, I want to thank you for taking the time to talk to all of us today, and I hope you can come back at a later time to continue the conversation.
Yeah, I'll email you that diagram if any of your members want a copy of it.
We would like that. So I want to thank Alex as well for joining me and thank everybody who joined us this afternoon. Be on the lookout for future webinars, and we will talk soon. Have a great day.
Bye-bye.